It's a story that might sound oddly familiar. A whistleblower blows the whistle, revealing failings within the public service. The Australian government then proceeds to prosecute said whistleblower to the ends of the earth. Richard Boyle worked at the ATO in Adelaide as a debt collection officer. His whistleblowing journey began in 2017 when he blew the whistle internally at the ATO after he identified what he alleges were unethical tactics being used for revenue raising. Boyle alleges staff were instructed to start issuing standard garnishee notices on every debt collection case. A garnishee notice is a debt collection tool that allows the ATO to order a bank to hand over money from a taxpayer's account without their consent. In other words, the ATO can issue a notice to your bank to siphon money from your bank account, clear your tax debts.
To summarise,
as this article in the Canberra Times says, think robo-debt but for small businesses. Richard Boyle first blew the whistle internally in October 2017, but his complaints were dismissed. So, in accordance with Section 7A of the Public Interest Disclosure Act, believing that his PID, or Public Interest Disclosure, had not been handled reasonably, he took the matter to the Inspector General of Taxation and Taxation Ombudsman, or the IGTO. This again went nowhere. Exhausting the internal avenues, he went external to investigative journalist Adele Ferguson and Four Corners.
In May, an email was sent to staff towards the end of the working day, encouraging them to issue more garnishee notices before their shift ended.
The last hour of power is upon us. That means you still have time to issue another 5 garnishees, right?
I was horrified.
You can still catch the 2018 episode of Four Corners on iView.
What was so abhorrent about issuing standard garnishees? Why was it unethical?
That meant, and I stated, that we may be shutting down the wrong businesses and causing great distress to the community, and possibly even pushing people towards suicide that needed our compassion, as opposed to the people that we should rightly be targeting with standard garnishees. This was a cash grab. My colleagues were saying this is a cash grab, clearly a cash grab.
The court has since determined that Richard Boyle's original PID, the one made through his efforts to blow the whistle internally back in October 2017, was not dealt with appropriately, and the authorised officer's decision to discontinue the initial inquiry was incorrect. I guess we can only speculate, sliding doors, but what would have happened had that initial disclosure been dealt with appropriately back in the day? This is something that former Senator Rex Patrick alluded to a few years back.
This is a guy that blew the whistle. He saw something going wrong. He's blown the whistle formally. We now know, the Senate has looked into this. We now know that that was a superficial investigation, and you'll see the comment I've put is, but for the superficial nature of the ATO investigation, all the remaining steps would not have happened. The perception that any reasonable person would have is Mr. Boyle, he made a public interest disclosure. It was rejected. We now know the ATO failed in its processing of his public interest disclosure. He then tried again with the IGT, failed again, and then went to the media. And we know that there has been laws that have changed as a result of these actions, and indeed the IGT has made findings that support his PID. Most people will look at it and say, this is a case where someone tried really hard to follow the rules, blow the whistle, and ends up being prosecuted. Only after he was charged was it acknowledged by the Inspector General of Taxation that the ATO were operating in a manner that was egregious and harmful to businesses.
Furthermore, 3 justices of the South Australian Supreme Court have recently said that the ATO accepts that the appellant is a whistleblower, as that term is commonly understood, and Richard Boyle disclosed information to an authorised person pursuant to the terms of the Public Interest Disclosure Act. Let's be real, the Commonwealth has spent hundreds of thousands of dollars prosecuting this guy so far because he had the cojones to speak out. Richard Boyle helped people. Dirk Fielding was one of those people. He was interviewed on 7:30.
Dirk Fielding's world collided with Richard Boyle's when he centred distressing facts to the ATO in May 2017.
I literally begged. I needed help. I wasn't trying to avoid the tax. All I was saying was that I just needed to get back on my feet, and that's when Richard contacted me.
If you haven't seen it, check out the full story on 7:30 for some more insight.
I feel absolutely terrible for Richard, who's put his life on the line to help me, and he is being persecuted to such an extent. It's just insanity.
Richard Boyle is a whistleblower, there's really no debating that. But Richard Boyle isn't being pursued by the Commonwealth for blowing the whistle. He's being prosecuted for what he is alleged to have done in the lead up to making the disclosure, and that is taking photos of tax records and recording some conversations to help support his whistleblowing. As it stands today, Richard Boyle is facing decades behind bars. This highlights one of the many failings of the Public Interest Disclosure Act. It's also where things get very messy very fast. Under the Public Disclosure Act, whistleblowers are provided some protections and immunity from prosecution when making a public interest disclosure. Under the Act, in making a public interest disclosure, a person is not subject to any civil, criminal or administrative liability for the making of the public interest disclosure. It's the interpretation of this, and in particular the word making, that has allowed the Commonwealth's prosecution of Richard Boyle to continue. While Boyle's lawyers have argued that immunity in federal whistleblowing law must extend to preparatory conduct linked to the whistleblowing, that argument has been rejected by both the trial judge and the appeal judge. As Kieran Pender, senior lawyer from the Human Rights Law Centre, points out in his article in Crikey, the appeals court decision confirms a very narrow approach to whistleblower protections in Australia. Only the actual act of blowing the whistle is protected, nothing else, no matter how closely linked to the whistleblowing. Pender goes on to say that whistleblowing laws also explicitly allow whistleblowers to speak up to journalists and MPs in certain circumstances. But now, they cannot provide any documents or information that is not already in their lawful possession. The protection is only to tell a journalist about allegations of corruption, not provide any evidence. How many journalists and MPs will take a whistleblower's word for it? You can see how this is going to make life pretty hard for whistleblowers, when the best they can provide in the way of evidence is a "trust me bro." And once again, just a reminder that the government today can choose to end this prosecution at any time. Both Labor and the Coalition have hidden behind the exceptional circumstances line for far too long.
The Attorney-General has power under the Judiciary Act to discontinue proceedings. That power to discontinue proceedings is reserved for very unusual and exceptional circumstances.
The exercise of these powers is reserved for very unusual and exceptional circumstances.
I reckon it's well past time for the Attorney-General to step up.
Actions speak louder than words.
While Albo and Dreyfus talked a big game when it came to protecting whistleblowers, they've proven themselves no better than the Coalition.
We don't need a culture of secrecy, we need a culture of disclosure. Protect whistleblowers, expand their protections and the public interest test.
Kind of miss the good old days.
But fortunately for them, they still have time to turn things around. They could choose to put a stop to the prosecution of Richard Boyle today, and rather than just talking about strengthening protections for whistleblowers, they could get in there and do it.
One last thing.
Finally, an update on David McBride. His legal team have lodged an appeal against his convictions on the basis that McBride believed it was his duty to release the information in the public interest, and they're also reportedly attempting to appeal the severity of the sentence. It's hoped that the appeal will be able to be heard in early 2025. In the meantime though, David McBride has served almost 6 months behind bars. What message do you think the government is sending by allowing the prosecution of Richard Boyle to go ahead? Or to continue to allow David McBride to sit in prison?
Do not do it.